Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Laurie Ehrlich explains how a master service agreement can be an operations document as much as a legal document. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen, Chief Community Officer at Law Insider and host of this show. We are glad to have you. Today I am here with my friend Laurie Ehrlich. Laurie, how are you today?
I'm good. Thank you so much for having me.
So you brought me a super long agreement, which makes me both love and hate you. This is a master services agreement as between Michaels and TCS, operating as TCS America, Tata America International Corporation. I'm going to ask you why this is so dang long. I think this is going to reveal a theme, but what is this document? What are we looking at? When are we going to see this kind of thing?
So an outsourcing agreement is generally a very long-term agreement where a substantial portion of one party's business is going to be performed by the other party. And the reason it's so long is because the volume of operational responsibilities that are addressed by the contract, it's way more than just a legal, this is the risks and this is how we're going to divide them. It's really and this is how you're going to perform the services for me.
Yeah, and we're going to actually here in a second go through the scope because I think it's interesting, but I just want to read a couple of these recitals real quick because it defines this relationship. Whereas supplier desires to provide to Michaels and Michaels desires to obtain from supplier the information technology services and related services and the business process services and related services described in this agreement, etc. So we are setting up this relationship where they're doing some IT stuff, but it sounds like they're also doing some business process stuff. Let's get more specific. I'm going to go down to the scope of the agreement, the definition, the description, the services. This is down in 4.1. Under services, it says scope of services. The term services means the services, functions, and responsibilities described in this agreement. And then in B and C, it starts to list them out. The services, functions, and responsibilities with respect to the services, functions, etc., described in 4.1a that were routinely performed in the prior 12-month period, etc. And then in C, it says any services, functions, or responsibilities required for the proper performance and delivery of the services that are inherent or necessary. So kind of a vague scope while defining the scope, which is super interesting. But I think to your point, the vagueness is sort of a feature rather than a bug because this is a big relationship. Tell me about what you're seeing in 4.1 and the definition of the scope.
Yeah. So 4.1a is what you see in almost any contract, right? You're going to describe what you're giving in an SOW. But because this is such a huge body of the business that's being given to an outsourcer, the customer is trying to control from the risk of maybe we didn't capture everything. And so B and C are what are considered sweeps clauses, meaning they sweep in the services that you haven't managed to list out in the SOW. And they're slightly different, so I'm going to take one at a time. 4.1b, what is happening in this contract that's not in this clause, but is referenced in this clause, is that the outsourcer is actually taking on a bunch of employees and just moving them from Michaels to the outsourcer. And so the concern for the customer is that those employees used to do stuff and now those employees aren't there anymore and that stuff still needs to get done and maybe it hasn't been listed out in the SOW. The risk here is that for the outsourcer is that they might not know what those things are that the employees did and they're looking for efficiency. So having the same people do exactly what they did before is not going to realize cost savings. And so usually they might change what they do, or they might move them to different places. And so tasks could get lost, especially ones that are once a year or infrequent tasks or, not a, one-off situation. And those are the ones, they might have been done in the last 12 months, but they haven't been documented anywhere. And so there's a real risk for the supplier in this case that it's going to be responsible for doing things that it has no idea that they exist. And there can be costs with that. And what this clause doesn't have in it that you often see as a way that suppliers mitigate the risk is the tasks get tied to the actual services that are in the SOW. So it's anything done in the last 12 months that is actually related to what is listed in the SOW, as opposed to just a catch-all for everything. And then,
so to ask a basic reframing I just wanted to ask real quick. Is this, so these are theoretically departments that could exist inside Michaels, right? Like Michaels could have its own teams that do these sorts of things. And so it seems like what this contract is kind of doing is like, because we're outsourcing, because we're taking things we could do internally and move them outside, these could even be mission critical. These could actually be pretty important services that we're creating this sort of weirdly, okay, you're not employees, you're not a department inside the company, you are an outsider, but boy, are we entangled. And so it seems like a lot of these scopes, it's leaving that sort of broad room so that we can say, we want to be able to play with you sort of like we would play with employees, like the variability of that. So we want to leave that flexibility. Am I reading that right?
Yes, it's definitely the flexibility, and that's part of also 4.1c. But it's not so much about like adding the kitchen sink, although I'm sure many customers would like that, because remember, this is at no additional cost. These are services that they don't get to charge for. They're worried, the purchaser is worried about being nickel and dimed for every little thing when they're saying, no, we just gave you this responsibility. You are now responsible. I'm done. You told me I'm paying you. I'm done. I'm just going to pay you that amount. You take care of everything. But it's more that both of these clauses are about, we can't, the scope is so large, we can't actually list everything out. If we listed everything out, we would actually spend the next year listing everything out, and that's not efficient. And so we're just saying, if it comes up, you're just going to do it. And the second, the 4.1c, which is the other sweeps clause, is kind of like anything that's related. So what I like to think about it, like to simplify it for my business teams, is imagine someone asked you to make a peanut butter and jelly sandwich. Did they tell you had to take the knife and put it into the jar? Or did they just tell you, make me a peanut butter and jelly sandwich? Well, obviously to do that, you have to actually get the peanut butter or the jelly out of the jar. And if that's not specified, that's still part of the responsibility. The area where it gets complicated is maybe not all of the peanut butter sandwich has been transferred to the supplier. Maybe the supplier is just responsible for spreading and stacking and isn't responsible for, say, acquiring the peanut butter and the jelly and the bread. And so one of the things that you usually see in sweeps clause to protect that is you make sure that the sweeps clause doesn't include anything that's been explicitly retained by the customer. So you don't want that sweeps clause to override what the parties have already said is, you're responsible for this and I'm responsible for that.
Yeah, I don't know why when I hired my landscaping company, they didn't also watch my kids. These are my requirements.
They're outside of the
all right.
wall.
They go outside. I'm going to jump down to 18.6, and I'm actually going to do a weird thing and read this whole thing just because I think this is super interesting related to what you just said. So again, context is we got this outside group, but are they outside? We're pretty deeply entwined. So 18.6 is titled due diligence. And it says, supplier hereby acknowledges and agrees that Michaels has delivered or made available to supplier all information and documents supplier has deemed necessary for supplier to commit to its obligations under this agreement in accordance with the terms. Supplier shall not be relieved of any of its obligations under this agreement as a result of its failure to review that information referred to therein, or its failure to request any information or documents from Michaels, except to the extent that Michael screwed things up. The point is, if I were hiring somebody and bringing them in and building a team, I would have to give them access to they'd have to have an orientation, they'd have to have documents, they'd have to have records, they'd have to have access to tools. This is sort of, it sounds like creating, hey, you need to kind of do that for us too if you're going to have that requirement for us. What is this section doing, and how does it relate back to what you just talked about in terms of the scope of the services?
So I'll give a little added context. The way an outsourcing agreement happens is first the customer puts out an RFP and companies respond and they give a lot of information in the RFP. And then they do a down select process and they choose, and sometimes multiple parties get to negotiate the contract with them and they see get better terms from. And there's a price that's tied to it. And that price is almost always subject to further due diligence. And while you're negotiating the contract, there's a simultaneous process, the due diligence process, where the supplier asks lots and lots of questions to understand what the actual scope of work is. What's the full extent of what we're doing? What are your SOPs? How did you do this before? How many people do you have doing this? Where are those people located? What's the hardware you're using? What's the software you're using? Every little detail. And sometimes customers are have all that information super organized, and sometimes it's not. Usually I'm going to go with it's not. And it takes time, and there's holes, and there's lots and lots of back and forth. And so this clause is a risk shifting clause saying, supplier, you are responsible for making sure that you have everything you need, and you can't change your pricing anymore because we've given you everything you need. And even if we haven't given you everything you need, you're still responsible because it's your job to figure out what you need. And I think that this, I regularly as a supplier would push back on this clause because you just really don't know until you're there. And so what I think you really like, the best practice is to have a tail on that. So you have X amount of time after you've taken on the services to come back and say, hey, this is also here. And I think, you leave some of it, right? If that information was actually provided, no, of course, we told you this. Here's the document that it's listed explicitly in. You can't come back and charge me for it. You should have read the document. But there is definitely information that does not get transferred in that process. And giving a period of time where it's not, like, you might not think to ask. You can't think of everything under the sun. There are unusual quirks that are not standard that everybody does. And like every company has quirks. You can't ask questions about every quirk. And so you need that tail. And the way this relates to those sweeps clauses before is we talked about before that anything that was being done by one of those displaced employees in the 12 months preceding, that's a big area of diligence that you will have missed, those one-time things, those, both either one time because that's the frequency of it happens, right? There's a lot of things that happen just one time a year, or it could be something that's in one-off. And you're just not going to capture all of those in this diligence process. And so what you really want, and with the sweeps clause and this, is a tail. Like, so you're not in breach if you're not performing. Instead, you have, if you aren't doing something, the customer will notify you that you're supposed to be doing this. And you have a chance to look at the diligence and see, was it there? Was it not there? Does it change the pricing? And if you only are in breach if you then don't perform at that point, or the parties might decide maybe you shouldn't be doing it. Maybe it actually should be one of those retained functions. So they're very connected here.
So it's not just give me access to the information that I need. It's I'm signing off, since we're displacing the work that those processes used to do. If that process is somewhere in your documentation, I've just signed up for doing all that stuff for the flat fee or whatever we described before. So that makes a lot of sense in terms of risk shifting. I'm going to ask you a very large question. Under 8.3, there's a section called managed agreements. It's all in caps throughout the paragraph, so I assume it means something. Walk me through 8.3. What's it talking about in terms of managed agreements? There's more about how you do invoices with these agreements. What is this section talking about?
So we talked about how you have the employees that are coming on. Often you have contracts that are coming into, and there's two buckets usually: assigned agreements where you're just taking responsibility for the whole agreement, and then managed agreements where you have some responsibilities but not all the responsibilities. So the assigned, the contracting party is changing. You are now the party that is responsible under that contract. Managed, it's a contractual obligation between you and the customer to take action, but you're not a party to the agreement. So managed agreements, this clause in this particular contract is a very simple one. It just says, essentially, you're responsible for renewals and termination and invoicing. The problem with that is supplier relationships often need to actually be managed, and there's no allocation of responsibility for that. So the supplier here is being tasked with the responsibility for reviewing the invoices and saying whether they're right or not right. But the reason it's a managed contract instead of a signed contract is probably because both the customer and the supplier are using that contract. And so what we're missing in this clause is the operational reality of who's responsible for the actual relationship. Who's responsible if something is going wrong with the supplier, not just from an invoicing perspective, but from a delivery perspective. And then what is the customer's obligation to give information to the supplier relating to their own use under that contract so that the supplier can actually accurately review those invoices?
This is a basic question and maybe taking us off course, but I was thinking about this company that is outsourcing this big relationship, presumably has been outsourcing in different ways in the past and probably has a slew of contractors. So I guess my kind of broad question is, in this kind of agreement, is the supplier that's coming on and saying they're gonna run this department or whatever, they're gonna take over these responsibilities, are who do they have to keep? Do they have to keep running these outside contractors that have been doing stuff before? Do they get full discretion to be able to hire and fire the way they want to be able to? Does that make sense? How many of those relationships have to keep going?
The answer is it depends. So the managed agreements, usually you don't have the right to, you would have to have a conversation with the customer to terminate the time you want to terminate. You couldn't just do it because they might be using it also for other functions. Let's say it's a ServiceNow agreement, right? And you're the outsourcer and you've taken on the help desk function. But maybe they're also using ServiceNow for HR or for legal because ServiceNow is function agnostic. And so you can't just decide that they're not going to use ServiceNow anymore because they're using it in other areas that you have not taken on. The other thing is same for assigned agreements. They are unlikely to be using those assigned agreements. It's your area, but they might have relationships with those suppliers that they want to maintain. And so it's usually not a unilateral, right? But sometimes that should be part of the diligence discussion. It should be part of the operation discussion. These are not, okay, we sign the deal, we go our ways, we give you deliverables. This is, we're talking to each other every single day. We are meeting monthly in detail about everything. And so it is a constant communication. And so that's the kind of conversation you would have. Sometimes though, when you have the assigned agreements, you can say, and your job is to supply, the outcomes we want, and we don't care how you do them.
Mm. Yeah, that's interesting. It reminds me of in my pre-law school days, I worked at Swift Transportation, and we were actually at the Walmart distribution center. We actually put Swift personnel in the Walmart distribution center, running trucks out of there. And so we had this weird relationship where we were outside, but we were inside. And so figuring out who owns what. And actually, one of the things we had to do in that role was benchmark. I'm jumping down to 10.3, 10.4, 10.5. It's using this word benchmarking over and over. There's someone called a benchmarker. There's something about comparable deals in here. What's this section talking about? What kind of benchmarks are we discussing in here?
So what we talked about at the beginning is these are very long-term relationships. Rarely are they under 2 years. Sometimes they're as long as 10 years. And so the pricing on day one is based on usually the economic conditions of the time when you're negotiating, with some forecasting on, what expenses you think are going to go up, what expenses are going to go down. Usually people expenses go up and hardware, software tends to go down, but that's not always universal. And so what usually the customer is looking for is they want to know 2 years. Usually this one has a 1 year period, which is less often done. I usually see 2 years because you have the first year is like a getting established, you're figuring things out still. And so the second year is really all steady state. And so you usually do it after that because it is expensive to enter this agreement. You don't want to enter into a new agreement a year later. You want to have that relationship last for a certain minimum amount of time. So not just the cost of the contracting, but the cost of the implementation of that, and the transition costs are huge. So a 1 year is a very unusual time frame for benchmarking. But essentially what you're looking for in the customer is, do I still have a good deal? Or has the market changed so that I could get better pricing from somewhere else? And so, you usually agree on a benchmarker. There's not that many companies that do it. It's kind of the same stack of companies. And then what they do is they have all this information, like, they're involved in outsourcing negotiations again and again and again and again. So they have all of this industry knowledge and they know what deals are comparable. And so what they're supposed to do is they're supposed to pick, a set of deals that have somewhat similar services, somewhat similar service level agreements, and say, okay, your fees are higher or lower, or your service levels are higher or lower. And so they can say, okay, you're getting a good deal, you're getting a bad deal, you're getting an average deal. The problem is none of these deals are apples to apples. And so what you'll see in this clause is there's a section that says the parties can have normalizing factors added in. So let's say the customer's decided all services have to be provided from the US. Well, that necessarily is going to be a more expensive contract than a contract where services can be provided from like India or Guatemala, or they're less expensive people places. So that would be a normalizing factor, that it has to be US only. And so the benchmarker can then either find deals that have US only, or they can increase the people cost to reflect the U.S. compensation as opposed to the offshore compensation. One of the things that this contract actually I think has an error because it says they should pick from no more than four and no less than four and no more than six. But I think what they're saying is you have to have between 4 and 6 companies in the set. Not that you're going to find 4 to 6 companies and then choose a set from those 4 to 6 companies. You want to have enough of a range that you actually have an average. If you only have one company, that's not a benchmark. That's just another comparison. That's not the benchmark.
Yeah, like you said, it reminds me of again, working in trucking, we would do benchmarks against standard mileage rates, right? Obviously, we'd have variable costs for things like fuel rates or whatever, but periodically, to your point, we'd have to go back, and part of the agreement was we'd go back and see, all right, what are other companies for this kind of trailer and this kind of it? So anyway, I give that analogy just to make another reference. But one thing I'm noticing we've done conversations about service agreements and these kind of larger agreements multiple times. And what we've often seen is, I'm thinking back to Darlene Tonelli's conversation about Salesforce, is that there's often attachments, right? Like, so you'll have like this core document, but then outside of that, you might have a sample scope of work document or a work order or whatever, or a purchase order. You'll have samples of what's going to come in this, and then you'll have other attachments that the attachments change more frequently than the core document. I'm on Law Insider. I see this document. I see attachment for the definition section. It looks like they've just extracted it. But I'm assuming that there's a reference made to other attachments. What else are you going to see around this kind of document, and how will it impact this kind of core contract?
So often you'll see an exhibit that's specific to changes. So what's the process for making changes to the contract? So again, you want this to be a flexible arrangement. Like, the business will change for both parties, not just from a cost perspective, but from what's needed, right? The life moves quickly. You want to be able to make changes based on what's happening. Let's say, BlackBerries go out of business and IT service is what you were doing, and now you have to change everyone's personal device to Apple or whatever it is. So you have to be able to have flexibility. So there's usually a change control process exhibit. There is always a service level agreement, which I know you've gone through with many people. You will have statements of work. Often those statements of work will have multiple attachment documents as well. So for example, this one with the managed agreements, right? The SOW will have one attachment that's the managed agreements, and one attachment that's the signed agreements, and one attachment that's the SOPs, and one attachment, right? It goes on and on and on, because these documents are not just legal apportionment of risk or what happens if something goes wrong. These are operational documents. And I'll say, as a lawyer, you have to understand the business. You have to understand not just what the contract says, but how is your team actually going to deliver the services? Because otherwise, you're just negotiating in the dark. It's terms without meaning.
Yeah. And I'm thinking about this in preparation. You made that point about this is more of an operations document than maybe a legal document. And I want to step back. Part of me says that's true of every legal document, right? Like it's defining the terms and who has to do what and who's delivering what when. I think maybe your point is that because this is a longer relationship, that it sort of changes how much detail that we have to include. But to your point, it also has to be kind of vague in order to be flexible. Talk to me about that balance, using contracts as operations agreements. What's the sort of strength in that and the weakness of that?
So I think, and to your point before about like the exhibits change more often, I think usually you want the things that change the most frequently to be in the SOW, not in the MSA level. And so the MSA level is a framework for, this is how we're going to approach this aspect of our engagement, and this is how we're going to resolve disputes, right? A dispute is an escalation, and governance procedures is often an exhibit that's attached to these agreements. Whereas the SOW is the details of like, here are the SOPs, and here's a list that will change over time. Because you often have actually a team, you should have. A well-run company will have a contract management team that will deal with the SOWs and all of those change orders. And one of the things that, there's two things that often happen in these contracts, and the biggest risk is scope creep. things keep changing, and the business people are not contract attorneys. They're not contract managers. They just want to get the work done, and they're not documenting all those changes. And so you end up having this force of dealing that's not reflective of the contracts. And so having someone who's managing the relationship and managing the documentation around the relationship is really important from a dispute prevention standpoint.
Yeah, I always say most of the legal work's done down on the docks. We don't realize that that's where most of the agreements are happening. Laurie, I appreciate that. This is actually a really cool agreement. He says, non-ironically, about a super long master
They're
service
less
agreement.
fun when you're actually reviewing and looking them up, and you're on page 120.
When it's the job, yeah. When you're looking for that one sneaky comma that's in the wrong place, I don't have to do that. Laurie, I appreciate that you're doing that work and that you brought this document to us. For people who want to reach out to you, learn more about what you do, maybe learn from you, what's the best way to connect?
LinkedIn is a great way.
Great. Well, we'll include a link to your profile over at the show notes at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We'd love to have you. Laurie, thank you again, and we'll see you all in the next episode.
Thank you so much.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.